Hello everyone, my name is Manvi and today I am going to tell you about the pleading under Civil Procedure Code. So let's begin. Every case in a court of law begins with pleadings. It is a written declaration submitted by the plaintiff's attorney outlining his claims for the case, upon which the defendant will submit a written statement defending himself and outlining the reasons the plaintiff's claim should be rejected. Following the filing of his plaint, the plaintiff may occasionally file a statement with the court's permission or the court may order him to do so. In a suit, this is the initial phase. Pleadings are defined as a written declaration or a plaint in Code of Civil Procedure, Order 6, Rule 1. Supplementary pleadings are the written declaration from the plaintiff and the additional written statement from the defendant. Now let's see the objective. The primary goal of pleading is to clarify the issues and present a concise picture of the case, which will improve and speed up the court process in order to present pertinent arguments and evidence in a court of law. The pleadings assist both parties in identifying their points of contention and areas of disagreement. In a ruling on a case involving a petition for amendments to an election petition, the Supreme Court noted on March 25, 1972 that the purpose of pleading tool is to administer justice and serve as a guide for a fair trial. Now let's see the rules of pleading. Plead, facts not law, is a concise four-word summary of the pleading rule. Instead of making recommendations about the laws that apply in a given situation, the attorneys for each party should only present the facts of their respective cases. The rules can be examined in two sections to obtain a comprehensive understanding of the same, namely fundamental or the basic laws, specific or additional guidelines. Now let's see the fundamental rules. Sub-Rule 1 of Rule 2 of Order 6 of Code of Civil Procedure Code 1908 discusses basic or fundamental rules. The following summarizes the provision and the fundamental pleading rules. First, arguments should be based on the facts, not the law. The first instance of this was in the Kedar Lal vs. Hari Lal case, where it was decided that the parties has a responsibility to provide the facts supporting their claims for compensation. In order to make a decision, the court will apply the law in accordance with the given facts. It is not appropriate to assert or apply any legal rights based on the facts as stated. Now let's see the other fundamental basic rule. Next is that material facts should be pleaded. Presenting only relevant facts is the second fundamental rule. Not essential facts will not be taken into account. In a court of law, the question of what constitute material facts actually come up. The judge in the case Union of India vs. Sitaram determined that all facts that the plaintiff and attorney would rely upon to assert rights or damages, as the case may be, or the defendant's defense would be considered material facts. In a nutshell, facts which will form the basis of claiming a right of compensation by the plaintiff or prove the defendant's defense in the written statement will fall under the ambit of being material. Third rule is the evidence should not be induced while pleading. According to this rule, pleadings must be include a statement of significant facts that the party is relying on, but not the proof necessary to support those claims. Two categories of facts exist. First, facts provenda, the material facts or the facts that must be proved. Facts propitia, facts or evidence by which a case is to be proved. Only fact provenda should form the part of pleadings and not facts propitia. The material facts on which the plaintiff relies for his claim or the defendant relies for his defense are called facta probanda, and they must be stated in the plaint or in the written statement as the case may be. Now let's see the next rule. Next rule is the concise facts ought to be provided. This concludes the list of fundamental pleading rules. When presenting the pleadings, a concise and a clear presentation style must be followed. At the same time, it must be kept in mind that in order to maintain brevity of facts, one should not miss out an important fact in the pleading. Pleading can be saved from superfluity if one takes care in syntax particular. The next is the particulars or other rules. First is the anywhere in the pleadings that fraud, misrepresentation, breach of trust, undue influence or willful default are pleaded, specific with the dates and items should be stated. Second is generally speaking, a party may not deviate from his pleadings, and unless an amendment is made, he may not assert any grounds of claim or make any factual allegations that conflict with his prior pleadings. Third is the it is necessary to specifically mention non-performance of a condition precedent in the pleadings, since it has already implied performance of the same shall not be induced in the pleadings. Fourth is a contract's validity, enforceability, or legality will not be deemed to be neglected if the opposing party disputes its fact. Some other particulars or rules are whenever malice, fraudulent intention, knowledge, or other conditions of the mind of a person is material, it must be alleged in the pleading only as a fact without setting out the circumstances from which it is to be inferred. Next is the unless the facts are material, there is no need for the facts to be stated in verbatim. Next rule is the pleading should only state the giving of a notice when it is required to give a notice or condition precedent without disclosing the form or manner of such notice or giving details of any circumstances from which the form of notice can be determined unless the same is material. The other rule is that implied relations between persons or contracts can be alleged as facts, and the series of conversations, letters, and the circumstances from which they are to be inferred should be pleaded generally. Other rule is that the facts which deals with onus of proof or which favors a party shall not be pleaded. Next is every pleading should be signed by the party or one of the parties or by his pleader. Next is a party to the suit shall provide with his and the opposite party's address. Next rule is that each and every pleading need to be proved by making an affidavit by the party or a person who is acquainted by the facts stated in the pleading. The other rule is that a pleading may be ordered to be struck out by a court of law if it feels the same is scandalous, frivolous, unnecessary, or intended towards embracing, prejudicing, or delaying a fair trial in the court. Now, let's see the amendments of pleading. Amendment of pleadings. Pleading amendment is covered by the rules 17 and 18 of Order 6 of the Code of Civil Procedure 1908. The goal of these clauses is to bring about justice in society. According to Rule 17 of the Code of Civil Procedure 1908, any party may be required to amend or change his pleading at any point during the process in a way that is fair and reasonable. Amendments may also be permitted when needed to settle on the precise issue that is causing disagreement between the parties. Likewise, Rule 18 addresses the matter of the pleading not being amended. The law states that a party may not amend after the expiration of the previously stated limited time or of the 14 days as the case may be, unless the court extends the time. This applies if the court orders a party to make necessary and he fails to do the same within the given time limit given by the order, or if no time is limited, then within 14 days from the date of the order. Now let's see the conclusion. The foundation of every legal action is its pleadings. The pleading lays out the case. It helps the parties formulate their claims or defenses by assisting them in understanding the other party's arguments and forming their own. It serves as direction for the entirety of the suit. Additionally, they establish the scope of admissible evidence that each party may present during the trial. The fundamental guidelines for pleading, as well as any modification to them, are established by the Code of Civil Procedure. The ultimate goals of justice are to be served by striking a balance in society through these provisions. Thanking you. Hope you liked the video.